So it is really my honor and my privilege to introduce to you Detective Constable Martin Franson from the Financial Crime Unit from Durham. And actually, it was Tanya Jewell from OBIA that had made the connection with Martin and I and introduced us, as he's also the chair of LEAPS, which is the Law Enforcement Agencies and Partners Protecting Seniors and also Vulnerable People. And so thank you for that connection. And I thought that this would be an incredible presentation to give to the OAC, talking about power of attorney and a list of will and testament and how to protect seniors and the vulnerable, specifically from somebody who certainly understands it from a certain perspective. And I just have to say that it has just been such a privilege corresponding and speaking with Martin and his passion for this. And LEAPS is, and I don't know, maybe Martin, you'll speak a little bit more to it, but really looking to be a provincial effort across the province about really protecting seniors and the most vulnerable. So I won't say any more, but Martin, thank you for joining us today, and we look forward to hearing from you.
Awesome. Thank you, Ruth. Thank you for everybody being here today. I realize, of course, you were forced to be here for your meeting purposes, but thank you very much. Yeah, I am Martin Franson. A little bit of history about me. Police officer now, 22 years. Please put your pens down. Do not turn your calculators on to add these years up. But prior to becoming a police officer, I was actually an officer in the Canadian Armed Forces, a military engineer. I had the honor of serving across Canada from Montreal west. And so change of career occurred back in the late 90s. In between there, I got my helicopter license, commercial helicopter license, which was kind of cool. And I've done a number of other things related to that, but I never left the country, which was always interesting until such time as I became a police officer. And then they kicked me out of the country twice. A lot of people don't realize Remembrance Day is tomorrow. Yes, service members. Traditionally, we look at people who are wearing the uniform of the Canadian Armed Forces, but a lot of people don't realize that at any given time, there's at least 50 police officers around the world in these hotspots, and at times it's as high as 100. So I personally served in Jordan when I taught Iraqi police officers in the desert, and was there for 14 months, right at the height of everything that was going on in Iraq, back in 2006, 2007, and then 2009, along with other police officers from across Canada, deployed to Afghanistan, and was there for 5 months, right in the very thick of it, working with the U.S. military and the Afghan National Police. But I just bring that to your attention because a lot of people do not realize that our police officers that you may see on the street one day may actually be in a foreign country trying to impart democracy through effective policing on a different state. So when it comes to vulnerable persons, which is a term I prefer to use lightly versus the word seniors, because seniors infers age, and no one should ever be categorized based upon their age. We have all capacities at different stages in our life for a variety of different things, and age should never be a barrier to having the opportunities that everybody else gets. So that said, I've been in financial crimes. Most people will call it fraud, but we call it financial crimes because when I am looking at the vulnerable, there's often not a fraud component by law. It is a crime involving the theft of their funds, their property, maybe you have, and not necessarily that it does involve a lie, which fraud tends to bring into that equation. In doing so, I've taken training through Osgoode Hall, York University on elder law, and to understand the civil side of things and try to understand the relationship between civil and criminal law. If you're not sure, they are two different worlds, very convoluted in their own ways. And then when you try to mix them through power of attorney, last will and testament, and other issues, it can get very, very muddy, for a lot of way of putting it. I also taken through Osgood a course on capacity and how it affects related to the law, and last will and testaments. And what I've been doing since 2015, I think it is, came to the realization that it is absolutely impossible that police can protect everyone. It's unrealistic to believe that. And the way financial crimes are, with a special target, shall we say, of vulnerable persons, annually, the losses are just off the charts. It's well over 100 million in Canada per year, a loss to persons over 65. And those statistics do not reflect reality, because a lot of people who are victimized will not come forward and report it. So of course, no reporting, you don't get the victimization accurate figures. So I'll do a lot of training, if you would, seminars to the general public, but also try to, where possible, to speak to organizations such as yours, your organization, and it's beautiful that you're across the province. Became aware of you through the Durham branch. Thank you to Heather and Tanya in particular, who we made a connection, done some seminars for their clients, but also just recently did some for their staff. And along the way, I'll tell you exactly as I told them, if I happen to scare you, it is deliberate and intentional, because I find that when it comes to this stuff, that degree of fear sometimes causes you just to step back for a second, and that momentary pause might be all that's necessary to, in your particular case, from a personal perspective, prevent you from being a victim, and in your the world that you work in could very well give you that opportunity to support someone else, your client, just that much better, which is obviously the great hope. I am the current chair of an organization called LEAPS, Law Enforcement Agencies and Partners Protecting Seniors. It started back in the late 80s, and it currently has membership across the province. 24 of the 52 police services are represented. And we have a number of community partners. Office of Public Guardian Trustee, for example. The Canadian Fraud Center has just come on board. Ruth has just come on board with us, which is awesome. And the idea behind it is, it's an opportunity not for us, not only to network, but as police officers to share information, share challenges, successes in the investigative world, but also to have a better appreciation of the challenges that organizations such as yours face, and where that relationship can be built. Because again, as police, we can't do it all. We know that, we realize that. But there is a component for us, and then there's a component, or multiple components sometimes in some cases, for those such as your organization to assist. And when you're assisting, of course, not only you're assisting that individual to whom we're all trying to help, but believe it or not, you're also assisting us. Because if you take on that component, if you would, the support component, for example, of someone who's come forward, then we as police officers know that they are safe, because that's extremely important to us. We know that they're going to get some services to help possibly the continued victimization or re-victimization. I often call it stop the bleeding. I steal that from first aid training. While then we can focus on where our expertise is, which is trying to figure out whether or not there is an actual criminal component here, and or work with the civil authorities to try to affect change, and ultimately, in some cases, hold people accountable for their actions, the abuse that they may have imposed upon someone. So the idea behind this training that we're going to do here is this is your time. And I use a slide presentation, which I will throw up now. And when I say throw, I said that softly, I guess. But it's intended strictly as a guide for me. I do not have to follow it in any way whatsoever. If you have questions, concerns, I ask that you vocalize them if you're able to, because I can't see the chat, or if somebody is monitoring them. When the question comes up, please feel free turn your mic on if you're comfortable. Video is even better. I always like looking at, as I call them, humanoids nowadays. We're so busy online and doing everything through computers, kind of lost sight of humans in this equation. So I call them humanoids, real people. But those questions, as they come to your mind, please feel free to bring them up. If you want to challenge me, please do so. I have no problem with that whatsoever. If you have some comments, insightfulness you want to add, please do so as well. Again, the idea behind this is for you to learn, hopefully, not only from a personal perspective, information that you can take and impart upon yourself and your own family life, but also in your organizational work environment, and ultimately where you can, when you interact with your clients, it can assist them, not necessarily advise them. It's a term I don't necessarily like using, but assist them to ensure that they are protected and at least have some understanding of what the rules really are about, because there's a lot of misinterpretations. Now, if I had the ability to poll, the big question I would ask everybody, there are upwards of 30 people on here. But if you're an average organization, I would probably suggest that maybe 10% of you have a power of attorney document. Fair. Possibly 10% of you would have a last will and testament. And I'm here to suggest to you that anybody over the age of 18, regardless of your current health status, whatever, should have power of attorney documents in place, not in play, but in place. And more importantly, a last will and testament, even young as 18. Unfortunately, we have no idea what's coming around the corner, what could happen tomorrow. And if you don't prepare these documents, as you're about to learn, if you didn't already know, it can get quite complicated for the failing to have the documents. And although if in a case of a will where you're not carrying the burden of loss, that's an interesting terminology though, burden of the loss, it now becomes incumbent upon someone else and possibly the government, the system, to try to figure out where and what should become of everything you've left behind. So it can be extremely problematic. When it comes to this stuff, especially in particular power of attorney, it is not about power. Unfortunately, I see it all the time. People think it is. That term power of attorney is used across the country. It is very much misrepresented, and it's of course in the title in Ontario. It is completely about responsibilities, unequivocally, without question, completely. It's also about accountability, which a lot of people don't realize. There's a lot of accountability when it comes in relation to power of attorney documents, as well as when it comes to the last will and testament. And misuses, there's unfortunately, morality, shall we say, is not the same today as it might have been yesterday. A lot of these laws are old. They were done a while back based on morality, the right thing to do, looking after your family. There are some cultures that still will have multiple generations living in under the same roof. Other times and the common trend is not so nowadays in Canada. But you can be held criminally and civilly liable if you're not careful. So this is important to protect you as an individual. It's also very, very important to protect your organization, whatever brain injury association across the province you're with, and ultimately to assist your client. So this is some of the stuff I was going to look at today. And when we get together next time, there's a list of things. If you're interested in the slides, I have already sent them to Lauren and she can send them to you PDF. So don't worry about that. I must put this disclaimer in, though, it's extremely important. I am in no way a lawyer. I'm a police officer. I'm not intending to ever become a lawyer or solicitor. I do not provide legal advice in any way, and I am not an expert. And when I speak about this, at the end of the day, I confuse most people in Durham Regional Police because this is confusing stuff on the surface. And therefore, when I speak, the words are my words, not that of the service to which I work for. And as I said to you, if I happen to scare you along the way, that was my intent ultimately. So I've broken down some legislation. If you're ever looking and having problems sleeping, you may find that some of this is relevant and helpful to you. So I broke it down based on the different areas. Death, unfortunately, passing. There is no nice way to say that word. So I apologize, but yet there is no better way of expressing that. You may hear me say when you've packed your bags and moved on, or trying to lighten it, but at the end of the day, it is a term that it means the end is here. We all, unfortunately, that point in life will be there. We have absolutely no idea when in life that will be. And we hope longevity for everybody across the board. But if you don't prepare appropriately for it, there is repercussions, unfortunately, if you would. There's capacity as well. And my apologies, there it is, the one for power attorney documents. One thing with power attorney documents we'll get into, but when we're going to break it down shortly, but a lot of people don't realize they're actually in the province of Ontario. And the reason I say province of Ontario, because every province, every territory in Canada is different. Every province and every territory regulates these components, that being power attorney and wills in that province through different legislation. And it can vary depending on where you are. We have no, as I'm sure you're well aware of, in Canada, we have no adult protection laws. We have some forms of statute laws provincially designed to try to protect adults, but there is nothing like in the US where every state has adult protection laws. Akin that to CS, Children Aid Society rules of reporting, investigating, that kind of stuff. We have absolutely nothing. So every province that you go to will change. So when I am speaking today, I'm speaking about the requirements for the province of Ontario. If you happen to have a client that decides to take up residency elsewhere than Ontario, another province, permanent residency, whether it be elsewhere, again, another province, territory, or they go to Florida for most of the year and that is their address, then they must ensure that they follow the rules and regulations regarding power attorney and last wills relative to that province, that state. And they, as they say, they're different in every case. So for example, a will written in Ontario, where you are technically a resident of BC, could very well not be considered valid in BC and would cause a number of issues. And you ultimately, you could end up being deemed to have passed without a will. And then of course the rules in BC on how that is disposed of with the government maybe taking a cut could very well occur. So moving on, if you are interested in further reading on that, I offered some more info to you. It's very interesting that you'll see the second book on there is a very interesting book. It's 2 inches thick and it's strictly on the word capacity, which is pretty amazing. And it's something that you folks deal with all the time. And when we're talking about capacity, by the way, I'm talking about mental capacity. Again, something I'm confident you folks must deal with on a daily basis with your clients. Is there any questions or comments anybody wants to make at this point in time?
Hi, it's Julie from the Brain Injury Association of Sudbury.
Hi, Julie.
Hi. Okay, I don't know if it's a question you can answer, whatever. So my mother changed her will a few years ago because my brother had passed away. So one of the things the lawyer told us at the time is that you had to go to the banks and that the banks would not recognize the power of attorney that the lawyer had drawn up.
So what happens often in the cases, banks are interesting organizations, and unlike credit unions, which are regulated provincially, so the rules are slightly different for credit unions, but the banks, an official bank, of which there are 5 big ones that we all know about, they're regulated federally. And they always, as most businesses, will ensure that the interests of the corporation are looked after and adhered to. So as you will learn in a few minutes, you can produce a will and you can produce a power of attorney without the services of a lawyer. What the banks will do when that document is presented to them is send it off to their legal department to determine whether or not they are happy with that document. So they will review it. And if they see problems in it, and the next time we get together, I'm going to show you a few and hope that you can pick up some interesting components of those particular documents, all done by lawyers, by the way, with the question, would you act upon it? And the banks are doing the same thing, the financial institutions. So they will review it, they make a decision as to whether or not they're comfortable with it. The trend nowadays when it comes to wills is that when the bank is made aware the person has passed and that there is a will in place, you are not required to do what's called probate, which means put the will before the court. Ultimately, the simplest meaning I can give you on that word. But the banks are often forcing that to occur. The inherent problem with that is it's cost incurred by the estate, but also as soon as you put it before the courts in Ontario, you automatically trigger what's called the estate administration tax. And the estate administration tax, which we'll talk about in the next session, is actually based on the total value of the estate. So your clothing, your furniture, the house, the dog. I always like putting the dog in because people don't realize it's property. The car, the cottage, the boat, all the toys, total value, regardless of whether or not your will says you want to give those particular individual items to certain individuals. So you want to bequest that car, go to your grandson, for example. When it goes before the court, you must add up everything, and then the province taxes the estate based on the estimated value of everything all inclusive. The reason the banks do that is to protect themselves. The justification they will use is protecting the estate. But I think you're going to see it happen more and more, which is very, very, it has a two-edged side to it. But I can tell you, estate litigation, folks, is huge nowadays. In 2019 in Toronto, estate litigation, i.e. challenges to will, there were more court cases than there were family law, divorce court, and child custody challenges, just to give you a comparative there, because it's all about money and people are seeking to obtain money through the wills. So I hope that answers your question. What a long way to get there, right?
Yeah. It kind of did, because what we ended up doing is my mom deals with 3 different banks, right? And we ended up going as a family, like the rest of us, my other siblings and myself, going there and filling out the documents that were required for the banks so that we could access her accounts after she had passed or she had lost her capacity.
Yeah, and there are 2 different things, of course.
Yes.
When the capacity is gone, so but be very careful of bank imposed power of attorney documents to do that. They deliberately want to do that. That was pushed by the federal government in 2015. You will see that pushed by a lot of financial institutions. If you have a continuing power attorney in place or general power attorney, we're going to talk about both those. And as soon as you sign one in the bank, you may negate the one that you have.
Oh, really?
So what ends up happening is that the bank and all those assets in the bank are covered, but everything else, the house, the dog, the cat, the disposition of all the management of all that other property is not covered because the last power attorney document signed voids all previous. So you have to be really, really careful signing bank documents. It makes the bank happy, but there's other problems to it. And what banks will do today, and again, we will talk about that, is try to encourage people such as your mother to have a joint bank account. And the reason they do that, again, pushed by the federal government since 2015, what it does is negates the whole issue related to power of attorney. Unfortunately, it also opens people up to a lot of fraud and victimization because, and I'm seeing it more and more, unfortunately, especially with the times that we are going through right now economically for some people, have been challenging over the last 2 years, that the account sitting there with mama and my name's attached to it, and I take some money, and then I take a little bit more money, and I start treating that account as if it's my account because my name's on it, and therefore by law I can. It's not necessarily right. Well, again, suggest to you it's completely wrong, but it's very challenging for me as a police officer and the courts to do something about that because the person's name is on that account. So it's extremely dangerous. We will talk about that issue more in the future.
Okay, thank you.
Anybody else before I get into the world of wishes? Anybody got a birthday today? Nobody? Anybody have one yesterday? No? All right. I was looking for Lauren, somebody to pick on, but I just got Lauren. At any rate, Lauren, as young as you are, you've had a few birthdays, I'm sure. Anybody ever put a cake in front of you and tell you that it's very, very important that you need to blow out the candles, but before you do, of course, you need to make a wish. But don't tell anybody your wish because it will never come true if you do. Does that sound familiar to people? Yeah, so we learned very early. Now, in my case, I don't blow it out. I just bring the fire department in. But we learned very early that the wishes must be kept to ourselves. Otherwise, it just won't happen. The unfortunate part is we carry that thought process through life. And we forget that there is a time in our life where we may not be able to communicate our wishes. May our wishes be that we stay in our home for as long as we physically and or mentally are able to. But we fail to tell anybody that upon my passing, that I wish for this to occur, a cremation versus a burial. And if we keep that to ourselves, how in the world do we ever expect anybody else to know what my wishes were? So a power attorney document, as with a last will and testament, are intended to express your wishes. The more clarity you provide, the better it is for everybody. Most importantly, of course, yourself, because you put that thought process out, you've considered in the event of, but you're also, whoever you've appointed to represent you has now some clear direction. When they present that document to someone, an organization, for example, of yours, saying I am representing under the authority of a power attorney for personal care, Mrs. Jones, and this is Mrs. Jones's wishes, what you're doing is you're giving clarity to that organization as well. It isn't an interpretation of the person presenting, it is what you want. There's no need for an interpretation. The clarity is there. The medical world, all across the board, now has clarity. Family members now have clarity, etc. So as much as we have learned for many, many years to hide those wishes, keep them to ourselves, they're private, I am going to strongly suggest the exact opposite is very important when it comes to wills and power of attorney documents. If at some point in time in your life, you need help because you are not mentally capable or potentially physically. I picked on mentally here because of the environment that you work in, and I'll try to stress more towards the personal care issue, but who are you going to reach out to? You know, is it legal for a spouse to now start speaking on behalf of their friend, their partner in life, just because the marriage license is there? Well, it is in the Healthcare Consent Act, but it isn't standing in front of the bank. Okay, it is, again, under the Healthcare Consent Act when you're talking about healthcare, but it may not necessarily be about determining where the person's going to live, or clothing that they're going to have, etc. So that's why the power of attorney document comes into play, and it's so important to have them. The problem with them, if you would, I think it's the most important document each and every one of us will ever have, more so than your mortgage document, your deed, the first car purchase, the wedding license, etc. All those are very important events in our life. They're all spectacular events in our life. But this particular document, the power of attorney, is there to protect us in the event of. It's like having an insurance policy. It's actually very inexpensive insurance policy. If we don't do a very good job of it, though, what it becomes is a blank check. Now, I always like to ask people this. I haven't had anybody, unfortunately, do it yet, though. But if you're in the habit of signing a blank check, it's MARTIN, FRAN, and you can mail it to my office. I'll be sure to happily accept it on your behalf. And in fact, I'll send you a thank you card. And it's, you're probably laughing at me. I can't see that, but if you are, I'm trying to lighten the thing, but it's unreasonable for someone to say, especially Martin, the police officer, saying, give me a blank check, because you're not going to do it. You just would not do it. But if you're not careful in the authoring of the power of attorney document, that's exactly what you've done. You've opened the floodgates, the ability for someone to access all components of your life property-wise, and hide behind the laws and literally steal from you. And just to give you an idea of just how bad it is, in the last 3 days, I've picked up 4 new cases. So, and right now I'm carrying 47 cases. So just to give you an idea how extensive this problem is. So it will be the most dangerous document, folks. If you don't take the time, your clients don't take the time. If you pass without a last will and testament, and I apologize, I forgot the last part of that. I don't know why I cut the word off. I'm going to have to fix that slide. You will pass in what's called intestate. And now always remember that. I think of the interstate highway of the US, just drop the R, intestate. And what that is a fancy legal term that means you pass without a will, without your wishes being recorded. In the event that that happens, first and foremost, there's no one there to speak on your behalf. So what happens? The simplest of decisions right at the very beginning cannot be made. Funeral, no funeral. Celebration, funeral. Cremation, burial. And the list goes on, because nobody has legal authority to do that. If you pass intestate, there's a very good chance that the provincial government under the Office of Public Guardian and Trustee could very well take control of the estate and then determine the distribution of your property in accordance with provincial rules and regulations. including tax rules. That may not be what your intent was, but you didn't bother to put it down. So shame on you, unfortunately. So I would suggest to you, again, everybody over the age of 18 should have a last will and testament, and that it will be the second most important document you will ever sign. Well, that said, both those documents or more, depending on how many you fill out power of attorney, should never leave your control. We'll talk about that later, but when you do them, keep them to yourself, keep them protected within your realm, do not distribute them. And until the time comes, then they can be distributed. And I'll explain why later, but a lot of times with our wills, we like to consider family members. We like to consider how important it is to take care of our loved ones when we're gone, our partner, our best friends, a charity, whatever the case may be. And what so very happens is, this is what I usually see happens to families when it comes to, for some reason, it seems to cause an implosion of families and literally destroys relationships, family relationships. So a person's passes, their legacy in life becomes the absolute implosion of their family. So by having a document, a will, and putting your thoughts down, your wishes with clarity will often alleviate that. Not necessarily fully, but often will alleviate that problem. Sorry. Any questions at this point in time? I ask that often just in case. I don't want to miss anybody. So believe it or not, the laws of Ontario, the laws being provincial laws, civil, are based on two things: concept of faith and trust. You have to have faith in mankind, and you have to trust someone. We all want to trust someone, which is most awesome. But as you probably didn't want to trust me with a blank check, I will always caution you on how important it is to, although have trust, but along the way, protect yourself, protect your clients, and protect your other family members. When it comes to writing of these documents, it can be in any form, believe it or not. In Ontario, we must use specific titles, which we'll get into eventually. It can be written by you or by a lawyer. And a lot of people ask, do I need a lawyer? Because it costs me money. You're right. But I will suggest to you that the value of a lawyer necessarily for the power of attorney documents, it takes a lot of that argument away from the bank when it's done by a lawyer. When it comes to a will, the more complicated your state is, especially those with children, in particular young children, or they are looking to set up assistance to their grandchildren, for example, over a series of years rather than everything at once. So you may have a client that's in that predicament. Then I would always suggest that they go to a lawyer, and the lawyer that they should be looking for is one who has experience in estates, not a real estate lawyer, not a criminal lawyer, but one that has experience in estate law, so that they understand how challenging this can be and can write these documents appropriately. In Ontario, anybody producing a power of attorney document or a will has to be over the age of 18. You must be a permanent resident of the province of Ontario. And when I say permanent, what I mean by that is not the immigration status. I mean that that's your mailing address. Ontario, 123 any street in any city in Ontario is your address. You must be of capable mind. Now, I throw it out there, maybe rhetorical to you folks, because again, it's hard to, when you're online, to get that feedback. But do you see a challenge in your world when an individual has to be of capable mind to complete these documents? I don't know your world well enough to suggest that it does or does not, but my thinking is it probably would be a little bit of a challenge for you in how to do that. And we can talk about that later, but they must be of capable mind. And we will look at capacity in the next session, and it's called testimonial capacity, which is higher than healthcare capacity. I would suggest to you that a good portion of your clientele could probably fall into this problem. And therefore, how do they get these documents with a capacity concern? There are ways to make sure that happens and make it legal, but it causes a few more steps to occur that they might want to consider rather than just produce the documents. And that last part of it is tricky for power attorney documents and the Conditions Substitute Decisions Act. And interesting enough, what it says in the Substitute Decisions Act, when you produce a power attorney document, in particular the one related to property, you must be aware there is always the possibility that the person you appoint will rip you off, which is pretty scary in my opinion. You're signing a legal document, giving someone else authority with the realization that they could possibly steal from you. And that is okay. Well, it isn't okay, but you are required by law to be aware of that. It's interesting. Your document, again, it can be any format. So it can be just a slip of paper. It can be a napkin in a restaurant if necessary. The conditions were such, I would not recommend it today, but it could be. It comes to a will, it has to be either handwritten entirely or typed entirely. You can't intermix them. You will see in a way of power attorney documents that people will often use the forms that you can get online. I really recommend they do not. And if you are looking for some suggested forms, I can send them to you in Word document format so that you can provide them to your clients if you so wish. The problem with the printouts, if you hit print from the Ministry of the Soljan's office, they have power attorney documents available. Part of it, of course, is printed. The other part is handwritten. And then the question is who actually hand wrote it and who authorized the content. It's supposed to be the individual. Not always is that the case. So to be legal in the province of Ontario for power attorney and a will, you have to have two witnesses. And a lot of people don't realize the important thing with the witness. They are not witnessing the content of the document. That is not their role. So they don't have to read the document. They don't have to see that you're leaving, your favorite collection of stamps to your grandchild. Not important at all. Their responsibility of someone over the age of 18, someone who is not related to you, i.e. not in your bloodline and not under guardianship of someone else, which of course would be suggestion of capacity issues, and they cannot be named in the document, whether it be the power attorney or the will. Their responsibility is to ensure they observe the person who's signing the document is before them. There are some technical abilities nowadays because of the electronic capacities, but generally speaking, they have to be before them physically. They have to observe them put pen to paper before them, that they are not being forced to do so, that it is of their own free will, and that they did it on a certain date at a certain time. That's what they're witnessing. They're not witnessing the content at all. And a lot of people get concerned about that. Again, they should be ultimately two strangers. And all they're doing is watching to make sure that when I put pen to paper, I'm doing it because I want to. There's nobody holding a gun to me, nobody threatening me. I understand cognitively what I am signing, and everything is above board. Are there any questions off that issue? That usually generates questions. Have I lost everybody? Hope I haven't.
Sorry, Martin, I'm just wondering, so if you had it done by a lawyer, would then the lawyer and say their secretary be able to witness for you? Or would you need two different people?
That's awesome, Lauren. Thank you. What you will find is the lawyer, as the author of the document, will not witness it. They might go find another lawyer in the office, a stranger, and maybe the assistant or the secretary will also witness. But the lawyer will keep themselves at arm's length. I'm the author, I'm the one that put it together for the client. I'm allowing them to do that in front of someone else. Again, showing neutrality in the part of the lawyer on the author of the document. So there's a bit of a conflict in there if I was a lawyer. And additionally, of course, to show using the witnessing the eyes of two individuals that can say, I didn't influence in any way this individual. They did it of their own free will, their choice. So
Perfect. Thank you so much.
you're welcome. Anybody else? No? I hope that's not too confusing. So again, any format, resident of Ontario. Now, if you have a client, again, that moves down to Florida, they can take their will with them, but as soon as they take up personal, the permanent residency, that's gone. And they have to come up with a Florida state power attorney documents and Florida state will. Okay, so some people don't
Sorry,
realize
it's
that.
Julie again from the brain
Hi, Julie.
injury. Hi. Okay, so are you talking about snowbirds?
Again, if they take up permanent residency, i.e. their address goes and becomes a Florida address, and Ontario address is no longer considered their home. So snowbirds tend not to, because of the regulations around the healthcare world. 6 months less a day, I think, is what it is. I'm not confident. I haven't become a snowbird quite yet. But there is a timeline, so they will continue to use their Ontario address, so they're safe.
Okay,
Okay, but if you reverse that and you come up here for the mosquitoes and hot weather of Ontario in the summertime, but your permanent residency is Florida, Italy, Spain, wherever, you must have to that location. Okay. Now, if you're lucky, since Julie, you brought that up, I'm going to go on this tangent here for a second. If you're fortunate enough to own property in Ontario and elsewhere, another province or elsewhere in the world, you could very well need, or you should have, a power of attorney document and a will relative to that location. I'll say Florida again, to manage that particular component. So what you would say in your Ontario will is that this will handles all my property and my that is physically in the province of Ontario. I have a second will, so you must identify the second will in that will that will cover off my property owned in the United States. And then there would be a Florida-based will that covers off your property in Florida. You can't write your Ontario will and give direction onto what happens on property in Florida, because the rules, the laws, the taxes, and everything else are different. And you will, there will be huge problems. It'll force it to go to the courts and a lot of problems. And again, Ontario court can't rule on Florida, Spain, Italy, wherever. So yeah, you will have two wills. So there is a possibility of two wills, but you must, in those situations, again, either it be you or your clients, they must identify in the Ontario will that that other will exists and the purpose of that. Very, very important. If they don't, and they technically will in Florida signed in Ontario, they could very well have just invalidated So in Ontario, you die intestate, or in Florida, you die and your house is looked after, but nothing else is. Crazy. I hope I have not frozen up. I apologize if it happens, folks. This internet is not always the best. In all cases, and as you'll see, I keep talking between power attorneys and wills. The reason I'm doing that right now is just to give you some insight on both. There's a lot of similarities between the different documents across the board. The rules are quite similar, generally speaking, and then we get into the specific documents after that. So I hope I don't totally confuse you. And if I have, let me know, please. So again, so in Ontario, if you produce a new power of attorney document or will, unless it specifically states there's another one out there and you do not wish to invalidate it, you automatically, upon your signature and the witness is signing, have invalidated it. You know, you technically in Ontario could do a new will every day of the week, or power attorney. I've actually seen 3 power attorneys created in 1 week. The family was playing ping pong with the senior, but taking them to different people. But every time that the last one is signed, it automatically invalidates the previous. So that old document goes in the garbage for all intents and purposes. It doesn't exist. As soon as you sign, as I said, you can revoke as the person who is this is about. So I'll define this terminology in a bit, but the donor, grantor, or testator. If your appointee, someone you've appointed, resigns on you, i.e., I don't want to be your attorney under power attorney, you're all of a sudden could be stuck because your document, if you only appointed one person with no additional person identified, you're now left with nothing. In cases of a general power attorney, which we'll get into, if the person becomes mentally incapable versus physical, the document is no longer valid. In the cases of all power attorney documents, they cease becoming valid the moment you packed your bags and moved on. So you put them in your bags, take them with you if you want, but they're no longer valid. And I've actually seen situations where people have tried to use power attorney documents after someone has died and gotten away with it because the financial institutions didn't know that the person had died. They caught them later though. And it just becomes very, very problematic. But as soon as a person passes, that power attorney documents are no longer in play. Any questions on that?
I have a quick question. What's your impressions of someone having more than one power of attorney at a time?
Great question, Laura. Well, I will go into that next go, but I will always suggest that they appoint. By the way, I'm going to correct you on using the term power attorney, and we'll do that in a minute more deeply. But it's impossible. You can't have a power of attorney. It is absolutely impossible. They don't exist, and I'll explain why in a second. But I always recommend that you consider having more than one person appointed, and I'll explain that relationship at a later time. But both from a perspective of attorney, but as well as the executor, the executor-ex of your estate, and how important it is to do that and the reasoning behind it. We will have a full discussion on that one. So if you can hang on to that thought process, I think it's extremely important that people do all the time. Okay, so we're going to look at some quick definitions. So let's focus on power attorneys documents in particular, because that's what people generally deal with on a regular basis, I would think. And in particular, your power attorney for personal care, which handles the health component, as well as where they're going to live, their shelter, their medication, their hygiene, their clothing, and their safety components. And I'm quite confident in your capacity. That is the power of attorney document you would see most often. But I'm going to tell you about the other one, the general first, and explain to you how important that would be and how useful that would be for your client and maybe yourself too. So a power of attorney document, if you didn't know, of course, it's a legal document. It becomes legal upon the bearing of a signature from the person and the two witnesses, provided, of course, he uses the title to talk about and is dated. It's that simple. And what it does is gives authorization for someone else to act as your agent, to act on your behalf, to do just about anything, unless you've restricted them. So I want you to imagine how many things in the day that you do, from when you woke up in the morning to clothe yourself, to deciding what you were going to have for breakfast. You're going to have that coffee first, cereal, toast. You're going to pay that bill, let's say, make decisions regarding a purchase, that kind of thing. And now you've appointed someone else and given them full authority to make all those decisions on your behalf. Because that's what you're doing when you produce a power of attorney document, potentially. In Ontario, we have 3. We're going to get into them in a bit. One terminology that is used is a donor. So the document, if you're producing the document, you are the donor. Now, I don't like that term. It sounds like this is you're giving away your money. You're not by any stretch of imagination, but it is a legal term, the donor. It's the person that the power of attorney is written for. The one that you will most likely see on a more regular basis would again be the power of attorney for personal care. And the individual that document is written for is called the grantor. They grant authority to someone else to speak on their behalf. That's where that title comes from. So your client would be the grantor. If it's your document, you're the grantor. The person you appoint in a general, again, I'm going to get into that in a second, becomes the donee. Again, not necessarily a term I like, but it is the term that the law uses. And there's the most important term of all that I see that professionals fail to use all the time, and they should be using it. So I challenge each and every one of you here today to start getting in the habit of using this term. Stop saying power of attorney. Stop saying POA, because it is impossible. The title is actually an attorney. And by that, we do not mean that the person is a lawyer, barrister, or solicitor. No, it's just an old English term that has meaning in law. And the meaning, quite simply, is it comes with responsibilities and accountabilities under the law. Fiduciary responsibility is what it's called. So the term, when you are talking to someone who is representing your client and says, I am the power of attorney for my mom. I want you to think about this in the future when you're interacting with that person. Watch their body language. And what you will find sometimes is that they kind of, the chest comes out, I'm the power of attorney for mom. You will see that they sometimes change that body language. Not always the case, but for some people, that word power, they've drawn from that certain misbeliefs that they have strength over someone else. They have power over someone else. They do not. They have absolutely no power over that individual. Their relationship could be one of power. That's a total different dynamics. But the idea behind that title is it's a document. It's a power of attorney document, a document that appoints someone else to speak on behalf. And the person before you, who is standing before you, who is there representing your client and speaking on behalf of your client about maybe some services that you have available to them is actually called an attorney. And the reason I'd like to challenge you again to consider getting in the habit of using that terminology is you take the word power out of the equation. They put it in the equation, get it out of there. Because again, it's not about power. By you using the correct term, you're implying responsibilities, and ultimately you're following the law, because the law says the title is attorney. From a legal perspective, it's very, very important that the correct terminology is used, but I'll suggest to you from just a respect for your client, respect for the individual, the grantor, the use of the proper terminology is important too. Get that word power out of the equation. Hard to do. I hear it all the time. In fact, I hear lawyers doing it all the time. And it's most unfortunate, because a person who's been appointed under the authority of a power of attorney document under Substitute Decisions Act is an attorney, not a POA, not the power of attorney. Have I stood in the soapbox long enough on that one? I hope not. Any questions on that one? No? Okay, so you're probably sitting there going, oh, he's throwing so much at us. Yes, now I know that there are 3 different types of power of attorney documents in the province of Ontario. Okay, so what? Well, let me break them down for you and help you understand them better so that you possibly use them in your own personal life, but also can you impart some awareness upon your clients, which ultimately is the benefit of us doing the seminar. So the first one, which is seldom used or not used as often as it should be in my personal opinion, is called a general power of attorney. What that does is it's a power of attorney document. So it's a legal document where you can appoint someone else, your donee, to represent you at a time when you physically cannot. So I realize that your clientele could possibly have capacity issues, but maybe that capacity issues aren't such that it impairs them from having clarity of mind to make certain decisions. It might affect some element of their decision-making process, but not make the management of their property. So when it comes to banking, they still able to do their banking, but physically, for whatever reasons, or because they wish someone to assist them, they want to give that authority to that individual. This is the document they should be using. They should not be using a continuing power of attorney out of the Substitute Decisions Act. It's the wrong one. They should be doing a general power of attorney. A lot of the banks have general power of attorneys available for their clients. And this document, again, if you're interested, I can send it to you in Word format. It's extremely easy to do. Let me give you an example of how valuable this is. As I told you at the beginning, I went and did 2 tours overseas. And a couple of days before I left the first time for Jordan, a friend of mine who happened to be a Crown attorney said to me, so you got a general power attorney in place just in case? And I went, I really don't know what you're talking about. So she quickly got me the form and explained to me that what it was is that why I am 12,000 miles away, 8-hour time difference in the desert. If something goes wrong back home, and I was just a new homeowner, by the way, that I can appoint someone, pick my sister, to deal with those issues back here. Because I imagine, you can imagine that 8-hour time difference alone, we didn't have the technology in 2006 and 7 that we have today. So banking wasn't done online. Everything's done through the cell phone, or more importantly, personal. So I did the document. And what I did in my particular case is I put on the power of attorney document that it would come into effect the day I left the soil of Canada, and it would no longer be effective the day I returned to the soil of Canada. And I'm so glad I did, because my tour was supposed to be 5 months and it became 14 months. And during that time, a lot of issues came up, everything from a cell phone, which I had set up for direct payment. Bell tried to say that I wasn't paying them. It was their mistake, but it had to be sorted out in my name. I had paid my city taxes before I left. The city made a mistake and had to be sorted out. Everything you can think of, your Visa card, or your credit cards, utilities, properties, everything. For my sister to speak, she had to produce that document to each organization that she wanted to interact with on my behalf. And there was a lot of them over the course of 14 months. Again, imagine the number of decisions you make on a daily basis. Now extend that over a period of time. From your client perspective, you might have a client that it is very important that they like an interaction with the financial institution, but they need somebody to help them with their banking needs. They're cognitively aware, but they just like to have someone with that knowledge to provide them that assistance. So what they can do is produce a general power attorney to give authority for someone else to represent them before the financial institution for that bank account. Now, the wonderful thing about this one, folks, is if you haven't listed the responsibility in that document, I can't do it. What I mean by that is if I put in there my document, my general, and that to access my bank account for the purposes of paying bills, and I would say my bank account at RBC, for example, for the purpose of paying my bills. The person you appoint, the donee, cannot walk into the bank account or bank and start taking money out. They can only pay bills. They can't sell my house. They can't sell my car. They can't take my dog because they don't have legal authority to do so, because I never gave them the authority to do so. So again, very helpful for your clients, potentially. And so that restrictions are imposed and must be in the document because the way the law is written. You must state specifically what you want them to do. It must also define the time frame. So from this date to this date. So only during that period. They cannot in any way take and sign a last will and testament on your behalf. They cannot create other documents on your behalf. It restricts them. It's a very good document that potentially everybody before me.
Alert
right now,
from restart.
all 30 of you before me right now could very well have in place. Just bear with me just a second. My computer is giving me a little bit of troubles. Again. Okay, sorry about that. So from your perspective and a client perspective, you could find it, these are the traditional uses, but how about if you're traveling? When the borders open up even more and you decide I had enough of this COVID stuff, I'm going to travel for 6 months. I'm going to go around the world and finally make my dream come true. Or a client of yours is doing that. This is the document that they should be signing for the management of property back home. Okay, as simple as a cell phone company, by the way. The cell phone companies will not speak to you unless your name is on the bill. Well, if you put the name on the bill, all of a sudden now that person has full access to your account and could abuse it potentially. So what happens is if you put them on there as a spokesperson on your behalf, which a general power attorney does, they can deal with the issues, but they can't impart decisions if you could. Reduces the inability or the ability to mismanage. Your clients might find it helpful if they're going to have a hospital stay, for example. They're going in for an operation. They realize that the operation is taking place next Tuesday. So they may set the document up to come into play on Monday, and that they've been told that they will recovery stay in hospitals a month long. There's at least 2 months at home. So that's 3 months. So they dated for that 3-month period. And in that time frame, they want to make sure their bills are paid. So they appoint someone, their donee, to represent them at the financial institution, whatever it is, to pay the bills so that everything stays proper. Again, at the end of the 3 months, they still own their house, their car is still theirs because that individual had no legal authority to do that. So this particular one, the easiest way to remember the value of general power attorney is a physical situation. When the individual physically is unable to manage the property for whatever reason, not cognitive. It no longer is valid or in play. Of course, it times out for the date period that you put in there. It is no longer valid if you produce a new one or revoke it, the donor, or if the individual becomes mentally incapable, which is a very nice feature of it, or upon death. Any questions come out of that? So again, the general, every one of you could have it. The other one that I didn't list on there, by the way, if any of you are a parent and you have a child that's going to study outside Canada for university and stuff, as a parent, you always think that they're your kids, therefore you can speak on them. Legally, as soon as they turn 18, they can speak for themselves. Actually, in healthcare, it's 16, but if there are issues here that need to be managed and your child is studying in Paris, your child over the age of 18 should have a general power attorney to give their parent legal authority to speak on their behalf on whatever that issue is. Cell phone company, for example, because you just can't call up and all of a sudden start talking to them. They won't talk to you. They're over 18, they're an adult. So you personally could find that you're using this. There's no questions on the general then. Nothing at all. I'm going to jump into ones that you will probably see most of, which is called the power attorney for personal care. Also, there's a second one known as a continuing power attorney for property. Both those fall under what's called the Substitute Decisions Act. In your environment, I would suggest that you most likely aware of it, especially if there's for healthcare professionals that are on board with us here today. You're probably quite aware of the Substitute Decisions Act. You realize that the Substitute Decisions Act covers off power attorney for personal care. It covers off continuing power of attorney for property. But did you realize as well, it governs the determination of capacity. It outlines the requirements for certified capacity assessors. It deals with the creation of the Office of the Public Guardian and Trustee, if you're not familiar with that organization. They have different components to them, but one is investigative, for then there's suggestion of abuse against a vulnerable person. They may be called in to investigate. That is the same organization that could, if you have a client who has capacity issues and no one else has been identified as their agent, they could be deemed by the court to be the guardian of that adult. You might already have situations like that. They're also the organization that if you pass without a will intestate, that they could step in and determine who gets your property in accordance with the laws. So that one act, that Substitute Decisions Act, is a very important act and covers a broad range of things. It does not speak to healthcare specifically. That's the Healthcare Consent Act, which I'm sure you folks are very familiar with, or at least assumption on my part. Excuse me. A power attorney for personal care. People sometimes want to equate it to, and I've heard of terminology like for well-being. We don't have that in Ontario. Enduring, by the way, we do not have in Ontario. BC has an enduring power attorney. We don't. I understand Australia uses enduring that verbiage. We do not. We do not have a power of attorney for health, and we do not have a living will. Although some people would think that we have a living will, we do not. But that said, the expression of your wishes in your power of attorney for personal care can very much be like a living will, in the sense that you can put a narrative in there to provide clarity on what you want to happen in the event something terrible happens. So there is only one title you can use in Ontario. As with the general power of attorney, the term that you must use is the power of attorney for personal care. If, as a professional, someone presents a document to you and it reads anything other than that with respect to the 6 components we'll get into in a second, I would strongly recommend that you would seek advice outside, because the document isn't an Ontario document and most likely is not valid. Okay, so if you see a document that says an enduring power of attorney, for example, from your client, that's a BC document. It is not valid in the province of Ontario. You must all be familiar with this world, excuse me, and I would suggest that you would fall under the first category there. But power of attorney for personal care has 6 categories that it covers off, or potentially could cover off: healthcare, nutrition, shelter, clothing, hygiene, and safety. The idea behind it, and this is a misnomer for a lot of people, because a lot of people will believe that when it comes to personal care, it is continuous. It is not. It is only continuous if the person's been legally deemed incapable. So you have a client that's before you. The client is able to communicate with you on a daily basis. They may not be fully articulate for whatever reasons, but they're still able to express their wishes. You're making decisions with respect to how their healthcare is going to happen. There is a power of attorney document in place, so they've appointed an attorney. You can have that conversation with the attorney, but you are expected under legislation to ensure you bring your client in that discussion. Not down the hall, not a secret conversation, in another room somewhere else where they're not a part of. You are expected under legislation to impart them as part of that conversation. That their capacity, again, unless legally being deemed, and we will get into that next session, that can offer challenges to you. And I'd be the last person to suggest that you don't feel those challenges quite regularly. But they are expected to be part of that conversation. They're expected to have input. They're expected to respect their input. And as long as it's not negative towards their ultimate health care or their well-being, it should be actioned. An example, again, goes back to the fact, let's take your client's going to go in the hospital. They go in and they know that during that operation, that operation is going to require that they be given anesthesia. And I don't know about you, but if that stuff is really hard on me and it takes forever for me to recover from it. And I would definitely not want to be driving a car, let alone making a decision on what to happen with my investments. So why I'm under the influence of that stuff, as well as why I'm in the operation, I will not have clarity of mind, and therefore I cannot provide clear direction, if necessary, to the medical practitioners. So what would then happen is that they could turn to a power of attorney document and ask for direction from the attorney if there was some medical issue that came up. But a couple of days are over. The operation was successful. I recovered from the medication. I now do realize it's the time of day, the day of the week where I'm physically located. The power of attorney document is no longer in play. That's why they don't use the word continuing like they do with property. One of the reasons. So it comes into play. It may be in for a little while and then it's out of play. It could be back in, out, potentially, unless the person has been legally deemed incapable through proper process. So again, you could very well have a client where somebody has come up to you, most likely said to you, I'm the power of attorney for your client, and then wants to be the one to speak on behalf of your client every time you have an interaction. Unless you have a document that says that that person has been legally deemed incapable, you should be carrying on that conversation with the individual. Does that make sense? Hopefully. I find it really problematic in the healthcare world because sometimes the stresses, responsibilities, the client takes a little longer to articulate. Therefore, it's quicker to go to the other person, the representative. The other thing, and a major misuse, not one that maybe you will see, but you could possibly hear about, is often people will try to use this particular document to restrict access to your client. So your client, the attorney says, you know what? Let's say the attorney is the brother, and the brother says, you know what? And your client's the mom, and says, you know what? I don't want my sister. I'm the attorney under the authority of the power of attorney for personal care. Do not want my sister interacting whatsoever with my mom. Please, if you ever have a situation like that, do not act upon that. This document does not give any legal authority to prevent access to an individual. Technically, under law, the only thing that can prevent mom from having interaction with her daughter is mom saying, I do not wish to interact with my daughter. If that doesn't occur, or it can be proven that it's for health or safety reasons, and it would have to be proven that the denial is required, there's a problem. And it would be, there's been lawsuits in the past, of which, by the way, are lost by institutions who have restricted access to individuals based on direction given under power of attorney for personal care. So, do be very careful of that. You put yourself and your organization at great risk if you do act upon such a direction, because it's not a legal direction. It's not allowed to happen. So don't be the one making it happen. Any questions on that particular issue? So sometimes people will say, well, what if I don't have a power of attorney for personal care? Do I really need it? And of course, that question is for them to determine. But I want to remind you that a power of attorney for personal care covers 6 categories. And I have them up on the screen. Hopefully everybody can see them appropriately. You will notice that healthcare, of course, is the first one on the list. I don't know if that was by design or not, but it is there. So in your world, I'm sure you've heard of the Healthcare Consent Act and substitute decision makers. And probably be exposed to that on a regular basis. So let me go to, they get, for some particular reason, my PowerPoint just caused me problems. All right, I don't know why that happened. Ignore that. I'm gonna just leave it there. I've got things to add. I don't know what happened to my PowerPoint. My apologies, folks. So back to my thought was that Substitute Decisions Act kicks into play. And you may very well have been exposed to it, especially if you're a healthcare professional. What the Substitute Decisions Act is, under the Healthcare Consent Act, is it tries to find someone else who can make decisions on your behalf at a time when you are not able to. If you look at the list of substitute decision makers, you will see that the first thing on there is a court order, guardianship. So if the person has been legally by court deemed that they need a guardian, then of course the guardian is going to speak on their behalf. The second entry, so failing a court order, is a power of attorney document for personal care. Power of attorney for personal care. So it is that powerful, that important. Spouse is fourth on the list, if you've ever looked at the list. Family member, like your children, is 5. 6 is your sibling. 9 is the office of the public guardian and trustee. So the idea behind it is that a healthcare professional needs a healthcare related decision, not a property decision, not a shelter decision, not a nutrition decision per se. They need a healthcare decision, and they can't get it. They will seek from the individual. They will seek someone out that has legal authority to speak on behalf. So the first thing they're asked is there a power of attorney for personal care? Sometimes it happens that the person appoints an individual who is not their spouse. I've seen it happen. And what happens then is legally, the spouse is no longer invited into the conversation. Can you imagine that causing problems? But legally, if there's a power of attorney document in place, they're not invited. They're not supposed to be in that conversation because you're having healthcare related conversation. So the privacy issues. So technically what has happened is the individual has said, I do not want my spouse to be involved. You may have that. You may have cases of that. And people go, well, why would you do that? Now, there's a variety of reasons why an individual might do that. One could be they don't trust their spouse. It is possible. Another one, which might be a little more common one, is that the spouse is has an emotional attachment to the individual. And what they're seeking is clarity of mind and clear direction for the medical people. And if you bring in emotions, build in stress, you may not get the decision in the interest of that individual that the individual wants. So what they realize is my spouse, as much as I love my spouse, they're very important to me, et cetera, they're not the right person to making clear decisions for me at a very important time in my life. So I have picked someone else. It's not for us to question why they've done it, but it's for you folks in particular to respect the fact that they have. So if you are reverting to the substitute decisions maker list under the Healthcare Consent Act, you, again, your power of attorney document, keep in mind if it exists, power of attorney for personal care exists, that attorney could very well trump family members, spouses, partners, etc. And you could be the one in the middle trying to be the referee. Just keep in mind that the law is on your side because you're following the rule, and the rule says power of attorney is number 2, spouse is number 4. Consent capacity board is in the middle. Number 3. Any questions on that particular issue?
Hey, it's Julie again.
Hi, Julie.
You're very informative. I wish I would have known this before I had taken my mother to the lawyers a few years ago. Okay, so when she set up her power of continuing care, she named myself and my 2 sisters, all 3 of us. Is that a wise move?
Ooh, okay. So I'm gonna throw a bit of a carrot at you to cause you to think, and then the next time we're going to speak about that, pull on from what Lauren asked earlier.
Okay.
About should it be 1, should it be 2, should it be 3? What I as much as I'm sure you love your siblings, I want you to imagine growing up with your siblings. And at times one of them is your best friend, so it's the 2 of you against the other one. Sometimes it's the best crowd, all 3 of you are getting along really good. Sometimes one just for the sake of being different is being different. Now you're all adults. You're all living your life differently. You all look at life with a different vision, different view, possibly. And so you bring a responsibility to represent mother, because it's not about you. It's not about Julie, sister, or Joanne and brother Bob. You, three of you, and your personal feelings and wishes and desires are not part of the equation. Only mom. But you guys couldn't get along to make a decision on what's for lunch. Is that the time now to have a vote on what you're going to do for mom? Thus 2 win over 1?
I can see a lot of hurt feelings.
5. Yeah, you could very well. And I've seen parents do that. And one particular lady had 5 because she didn't want to have her children's feelings, and by leaving one of them out. I would suggest to you, and in the worst case scenario, and I apologize to everybody, but this is reality. I want you to imagine for a second, the mom is laying in the hospital bed, and the healthcare professional has turned to the substitute decision maker using the Healthcare Consent Act, which there's a power of attorney for personal care in place. You're no longer the daughters and the son, you're the attorneys. You're required to make a decision. The medical professional has turned to you and said, we have a couple of options. Here's the side effects associated to the first one. Here's the concerns and the risks with the other one. We need a decision. And you start arguing over what's for lunch. Or you start going, well, you know, I'm the oldest, therefore I know best. Or who knows what dynamics come into play. We not only have a problem for mom, but we also have a problem for the healthcare professional, don't we? Because they can't get clear direction. So my personal opinion is be cautious of 3. So you don't get the beating up. Definitely not 4 or 5. This isn't a democracy. And just a hint to you, as I'm sure Lauren's already picked up, I often try to recommend to people that they consider 2. And I'll explain why next time when I break all that down a little better. But like I said, my apologies, I lost a couple of slides. I don't know what that happened, but keep in mind, like these 6 categories are under personal care. Keep in mind that the choice is yours. But the ultimate point that I forgot to mention too is, in answer to the question, do I need a power of attorney for personal care? The answer is your choice. Because in the event that something happens to me healthcare, the healthcare structure is already set up that they can seek someone else to make decisions on my behalf in my best interest. Substitute decision maker. So the medical world needs a clear decision. I'm not capable of it because I'm under the influence of an anesthesia or a drug or whatever. They turn to the substitute decision maker, SDM. There is no guardianship in place. There's no power of attorney in place. Consent capacity board isn't in play. I'm switching to a spouse. Okay, I've turned to the spouse now. I get clarity of decision. I move on with the healthcare issue. Cool, I'm now taken care of. I didn't need my power of attorney document to have those decisions made. However, without a power of attorney for personal care, who has the legal authority to speak on my hygiene? Who has the legal authority to speak about my clothing or where I'm going to live? My nutrition. The Healthcare Consent Act does not cover that. The only place that is properly covered off, Substitute Decisions Act, power of attorney for personal care. So if you have a client saying, do I need it? I would always suggest to you, this is the way I express it to people. It takes you a couple of minutes to express it to them. But when they realize that no, they don't need it to protect them healthcare, but that is only one component of their personal life. that needs to be protected. And without having a power of attorney for personal care, those components are now left to someone else. And who ultimately could that someone else be, by the way? Anybody have any idea? A guardian. And for a guardian to be in the equation, court. So where those decisions could be a timely decision, maybe. So it might have to go to the consent capacity board, for example. But ultimately for an appointment of a guardian, especially on personal care, the courts don't like to do it because it's personal liberties. That is going to be a court process. So do you need it? Simple answer, no. Best answer, definitely. I hope that gives us some clarity there. Now, if I've timed this right, that leaves about 10 minutes, Lauren, people can toss things out in preparation. And I hope I gave you some good thoughts for the next time to give you dangle a carrot. So the next time you want to come back and I haven't totally bored you, where we will pick up on the power of attorney for property. I realize it doesn't affect you definitely professionally, maybe, although you might have interaction because there are decisions made. You know, personal care decisions that require the finances to pay for it. So that could very well require the continuing power of attorney for property, a relationship there. We'll talk about 1, 2, 3, 5. And what I want to do is break the documents down for you based on each paragraph and give you some thoughts under each and show you how you can quite simply, when I say you, I mean your client or yourself, can personalize your document, provide those wishes, provide the clarity so that that clear direction is there for everyone across the board. For personal care in particular, in event the worst case scenario happens, you're protected as an individual. And then I'll give you some thoughts of that you're more than welcome to share with your clients. And again, express in your own personal environment, your world, what to do with those documents once they're produced. And I will put up a few on the screen, and I'm going to ask you to quickly, simply, if I presented this document to you as your client, would you act upon it? So that'll be the next go. Are there any questions at this particular time? Any comments?
I kind of have something I wanted to throw at you, and I think it might fall under the same area as what you were just talking about with Julie, but I'm just curious. I have a client that I support who has a attorney, I guess, trying to use the proper language here.
Well done. If I could, I'd give you a big star right now. So I'll give you a cyber hug.
Attorney in place for personal care. But the problem kind of comes into play because the client has issues with alcoholism and opioids. So a lot of times they will call while under the influence and make changes to different situations with their healthcare professionals or appointments or different things, and then have no recollection of it, or it is against what they had previously said when they were in their right state of mind. And it leaves the person who is in the attorney position often wondering what their position is, because this person is sometimes in a good state of capability to make decisions, but nobody really knows when they're not, and they're just picking up a phone and randomly doing things. So I'm curious to hear your thoughts around that.
That's a very good one. And I would imagine your different branches across the province probably experienced something similar to that. So the first and foremost, my question would be to you, is your client being legally deemed incapable?
No.
Okay, so then my question to you is, why are you talking to the attorney?
Well, they have the client has indicated that they want that other person to be contacted and done because they get things mixed up and they don't keep track of things well enough themselves.
Okay, so in that case, what I would suggest to you, and again, I'm not a lawyer, but I would suggest to you in this particular case is they've given you an alternate contact
Yes.
of which you would have a discussion regarding appointments, but you wouldn't get into the nitty gritty of health because the whole healthcare Privacy Act, right? So where you would speak of saying, okay, I just wanted to confirm that client George is going to be here tomorrow at 10 o'clock. And the person goes, great, thank you. I'll make sure they're here. And you don't carry the conversation on beyond that. You know that better than I do.
Absolutely.
Yeah. So when you're talking to that individual, you're not talking to the attorney. You're talking to someone they have appointed as a contact. And I would personally, if it were me, again, I can't tell you what to do, and I would never want you to suggest that I'm doing that. I apologize if that's the impression you would get, is that I would look at them strictly as an alternate contact. They're not the attorney, because that individual has not been deemed incapable. If you were to look at the power of attorney document, probably in paragraph 3, we'll see that next time, where it says, when I am legally or in accordance with Substitute Decisions Act, paragraph 4, that I am not capable of making decisions with respect to my healthcare. What they're telling you right there, if that's what it says, or a permutation of that, is I need to be tested. And if I haven't been tested and I don't have a letter of opinion that says I am no longer capable, or a court has said I am no longer capable of making my own decisions, then that document shouldn't be in play. Yeah.
All right. Thank you.
Yeah. So now I realize from talking to the Durham organizations, sometimes some of you, depending on your professional capacity, the Healthcare Consent Act has an effect on you and governs you. So in that case, if you're working under the Substitute Decisions Act and you're looking for a substitute decision maker, then I definitely go down the list. Remember the list I gave you? You would work your way down the list. It's in the Healthcare Consent Act. But again, that when you're going down that list, no court order, guardianship, okay, there's a power of attorney. I'm now going to speak to the attorney under the authority of, because I can't get clarity of mind for a decision related to healthcare. But you can't extend that to shelter, clothing, hygiene, and safety. Does that make sense? You're focusing at that point in time.
Yeah, very much so. Thank you.
That helps, that offers a little bit of clarity there. And the problem with a lot of this stuff, though, and I'm glad you actually brought this up, Shannon, is that so often people believe, and in the best interests, they act, not realizing that you're actually exposing yourself to problems. And because where is your authority to have that conversation with the individual about the fact that they've got an ingrown toenail? I know I'm being ridiculous there, but it's a healthcare issue. You're not supposed to share that. You think that you're doing the right thing. I would compliment you in trying to do the right thing. That's awesome. But unfortunately, at the end of the day, professionally, which is great, but some people don't necessarily interpret that as the right thing. And then it just goes south for you and your organization. And you never want that. The risk is too high to you. Anybody else? No? I hope I impart something upon it and haven't totally bored everybody or scared everybody. I don't realize how many we still have on board with us.
Martin, it's Carol. You're pre-warning us that you were going to scare us. Well, you certainly have done that. But this information is, I'm glad you're sharing the deck. It's really valuable. So thank you.
Thank you. My pleasure. Yeah, and I hope to build on that, like I said, next go around, so that we can take that away and not only use it from a work perspective in your professional capacity, but also in your personal life. And if nothing else, when you walk home today, have that discussion about the need for a will in your life with your partner, or more importantly, look in the mirror and have that with yourself. Because we all, regardless, even your children, for those amongst us who have the adult children over the age of 18, you should be imparting upon them the importance of having power of attorney documents and a will. We'll get into a little bit all more of that next time. So,
Martin, I have a question.
sure.
If someone is a power of attorney for personal care, how is that invoked, or who invokes it? Or like, does someone say I was the attorney for my husband?
Okay.
Can I just all of a sudden think, oh, you're not capable of making decisions about your nutrition or hygiene anymore? Or does a professional have to say, okay, you're the attorney now?
Okay, so a professional won't say that. What happens, and we're going to talk about the scale of capacity next time. But what happens is that you're a healthcare professional. So is it fair for me to assume you're familiar with the term informed consent?
Yeah.
Okay, I apologize. I'm not trying to insult anybody
No.
here. So informed consent is the ability to, based on the information provided, make a decision or understand the ramifications of not making a decision. Right? Here's your options available to you. I need you to make a decision. And in the healthcare world, if that doctor is making that presentation to you, here's A or B. There's always C, because there's a second opinion offered, right? I can go get a different doctor, second opinion, more research, etc. But my options are A or B. But I realize that if I don't give a clear decision relative to A or B, and I don't go with that other opinion, that I am now at risk of the disease manifesting to ultimately death, let's say. But if I realize that and I turn to the medical professional and say, no, I'm not choosing A, I'm not choosing B. And I fully understand that by doing it my way, I could die faster. You're left with no course but to respect that, correct? It's informed. You're safe. You inform them. Pros can't do that for you.
Okay. And I think you just froze, Martin.
Can't formula that. Yeah, that's it. Sorry. Oh, it happens. My apologies. You think they can't give you that response, and so you're left hanging, looking for a response. Are we still good or am I frozen?
Oh, you're coming back
I
now.
think I'm frozen.
You're still frozen, but we can hear you a little bit now.
And folks, I don't know why, but in Bowmanville, the Wi-Fi seems to be terrible here sometimes. So I was having a conversation about that informed consent and the lack of. So the individual sitting in front of you can't give you informed consent and it's related to healthcare. You have the substitute decision to act as a healthcare professional to back up. Correct?
Yes.
You
In regards to
so
healthcare.
Right. Now I want to have a conversation beyond that. My concern is their shelter, for example. So the LIN will often come in. They will do an assessment based on people's ability to speak under shelter. And I often hear the LIN will say, I deemed them incapable. Well, they can't. If you look at legislation, they're not legally authorized to deem anybody. But they will help in the decision-making process. But without a power of attorney document, it's very hard to do anything.
Mhm.
Oh, you cut out again, Martin.
Have that conversation with So you have the document in place. Or am I back? A couple of fixed spaces. Am I back at all, Lauren?
Your video is gone.
Gosh, what happened to the internet? Okay.
Maybe if you
So-
stop sharing your screen, it'll speed your internet up a little bit. Yeah,
Try that. How's that?
good,
Is that
better.
better?
Yeah.
Okay, my apologies, everybody. So that informed consent is so important. You've got the alternate is your Healthcare Consent Act. If you want to speak in the other 5 categories, you don't have that fallback. So now it becomes a problem. So you might have to do a referral to the Office of Public Guardian. You may have to say this person is a risk, there's a capacity concern, and there is an immediate risk to their safety because of X, Y, Z. That might be the ultimate the recourse that you have, because there is nothing else, unfortunately. Did that help at all? In broken internet? I'm sorry, I forgot the lady's name that was asking the question, so my screen didn't come up with it. No?
It was Terry.
Oh, okay, thanks. So Terry, did that help you? Not sure if she's with us. Okay. Are there any more questions?
Yes, it did. Sorry, I couldn't get my mute off.
Okay. No problem. It's good to know I'm not the only one, Terry, that has this problem. But yeah, that's what makes this so challenging sometimes, because it would be really nice that we had an organization that we could then call in, like Adult Protection, and say, you know, this person is not making clarity of mind decisions. There's no protection in place other than for healthcare. We need a process to step in and help, and there's nothing. Technically, there is nothing, because the Public Guardian is there. They're a great organization, but their threshold is so high, and they will try to defer to someone else. And if I defer it to a family member, for example, where's your legal authority to make decisions? Because you're in a partnership relationship, you don't have the legal authority. So then that individual has to go to the court and seek guardianship to do it properly. And as an organization, the direction from that person, that partner, you can't really take direction from them. Because unless they walk and present to you a court order document from the Supreme Court of Justice, Ontario, that says they have guardianship over this individual for personal care. It's one of the unfortunate parts of this act, Substitute Decisions Act. It's a big hole in the act. And it's very, very problematic.
Well, thank you so much, Martin. I think that our meeting was supposed to go till 12, and so I'm sure people have really, I've seen some comments in the chat that it's easy and understandable, and I think, you know, what I convey Terrell's words as well, but also I think it was great for our clients, and I think it's great for us personally, and thank you for challenging us both professionally and both personally. We really appreciate it and look forward to having you back in a couple of weeks. So thank you so much.
Awesome. Thank you. Thank you to meeting all of you. I hope you get the opportunity to actually meet some officers in your local area. As I work with Ruth, we're going to try to make more of that connect. We actually had that connection this week taking place between Lauren and Ruth up in North Bay there. And if you're looking for that connection, do get in touch with Ruth or Lauren, and I can connect you with an officer in your particular area. If you're not working with them already, maybe you're able to establish that relationship, because that would be most awesome. Thank you very much, folks.
Great, thank you.
Thank you.
Melissa, Terrell, did you want to wrap things up?
I've already said to Martin that he was right. He's got me woke to the realities, and this information is so important to the work that we're doing. So thank you to OBIA for scheduling, and Ruth and Lauren for getting Martin to come and present to us today. Thank you so much.